The final case set for argument this morning is case number 18CA0034M, Keith Stamper versus Belle Distributors, Incorporated. Both parties are represented here for arguments today, so each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know and I'll keep track of time for you. The arguments in the 9th District are recorded and played on our YouTube channel, so we ask that you stay at the podium during the argument and keep your voice up so there's a good recording. We have read your briefs and are ready to proceed if you are.
Good morning.
Morning.
Good morning. I'm David Kovach on behalf of the appellant, Belle Tire. I request that you reverse the decision below and enter a judgment that Mr. Stamper is not entitled to participate for the remaining injuries in this case. The mental condition having already been ruled against him below. This is a de novo review because we're challenging the denials of 3 of our motions for summary judgment, directed verdicts, as well as the motion for judgment notwithstanding the verdict. Excuse me, I'm back up. I'd like to reserve 3 minutes of my time.
3 minutes.
Thank you. Waller versus Mayfield is the key case in this case. It's the key decision to base on. As Waller discusses, there are 3 categories of risk. The first, which is universally compensable, is a risk that's directly associated with employment. We don't have that here. We would have that here if there was something wrong with the truck. If it malfunctioned, if somehow fumes seeped into the cab and caused Mr. Stamper to pass out. We'd have it here if there had been a mechanical failure with the steering or with brake or something that caused the wheel to be ripped out of his hands. None of that is here. What the next category is risk that's personal to the claimant. This is universally not compensable. There is evidence, and the evidence in this is that there is in fact such a risk in this case. What precipitated the collision in this case was a loss of control of the vehicle by Mr. Stamper. He was cited for failure to control, paid a fine for failure to control. So what the key issue is what caused him to lose control? Now, he says his testimony is, I don't know. What evidence do we have in the record? The record is that it's a dry. The weather is fine. It's a dry pavement. He's going straight. He's had no problems. He had no problem going down to Orville. He's had no problem coming back from Morville over to the Canton area the Akron area where the accident occurred. He doesn't know what happened. The vehicle, however, slowed. There's no activity with brake lights. The witness says no. There's no vehicle in front of him that he has to avoid or attempts to hit him. There's nothing wrong with the road. He loses control. It hits the median. It slides down the median about 200 feet. So there's no external issue causing the accident. So what then caused him to lose control? Dr. Mark, who treated him in the emergency room and thereafter, said most possibly syncope, which is a temporary loss of consciousness. He could have fallen asleep. Something happened with respect to Mr. Stamper that caused him to lose control of the vehicle. That says it's not compensable. Now the question becomes, well, there's a risk known as neutral risk, it's neither one of those. It's not clearly one risk associated with an individual, nor is it a risk associated with the employment. Giving Mr. Stamper the benefit of the doubt, there's a neutral risk here. And Waller says that where there's a neutral risk, he bears the burden, not the employer. He bears the burden of eliminating, that is, ruling out all idiopathic risk. All idiopathic causes. Syncope is an idiopathic cause. Falling asleep is an idiopathic cause. If I can digress for a second, if he falls asleep, he has sustained an injury. And the falling asleep or the syncope has to be related to the employment. It's not solely that something happened at work, but it also must happen because of work. So, did he fall asleep because of work? There's no evidence to support that. Did he have a syncopal episode because of work? There's no evidence to support that. Did he have a syncopal episode? I don't have a burden of proving that. But literally because I have no burden of proof. However, the evidence establishes that there is likely a syncopal episode. There certainly is the existence of the possibility. That's Dr. March's testimony. No expert testimony was advanced during the summary judgment stage of this case. What's advanced in summary judgment? Traffic crash reports, which shows the condition of the roadway, the fact that no brake lights were activated, and that the vehicle veered off and then slid down. That's consistent with syncope. That's consistent with falling asleep. The burden at that point becomes Mr. Stamper has to respond with some evidence. He responded with no evidence. And the trial court simply said, there's a genuine issue of material fact. We don't know what that is. It was never articulated. Same thing with respect to the denial of our motion for directed verdict and the motion for judgment, notwithstanding the verdict. In Waller, there's an interesting passage. It's at page 123 of the opinion. And it reads, bear with me for a second. And this is referring, in Waller, it was a slip and a fall. It should be stressed that the present question, internal weakness causing a fall, although often discussed in the same breath with unexplained falls, is basically different, since unexplained fall cases begin with a completely neutral origin of the mishap, while idiopathic fall causes begin with an origin which is admittedly personal and which therefore requires some affirmative employment contribution to the onset, or to offset rather, the prima facie showing of personal origin. And it is the latter part that I'd like you to focus on. The syncope, or the falling asleep, or whatever caused him to lose control, is internal, it's personal to him. So he then has to show some affirmative connection to employment. And simply being in the truck, simply driving a truck is not sufficient. Again, if the truck were defective in some way, you would then you got a connection to employment, a causal connection to employment. There's nothing indicating here that there's nothing to indicate that here. So, with the burden upon Mr. Stamper to eliminate all idiopathic causes, he failed to meet that burden, simply because Dr. March's testimony. Now, Mr. Stamper in his brief has talked about Dr. Meekum. Dr. Meekum said he didn't suffer syncope as a result of hypertension. That's correct, he did. That evidence is there. Dr. Meekum also said that there are many causes of syncope. We don't know all of them. In fact, many people don't even know there's anything wrong with them, and they have a syncopal episode. So syncope has not been eliminated. And because it hasn't been eliminated, then you fall back to that paragraph in Waller that says you've not eliminated all of the risk. You have to rule them out. You just can't simply say it's only a possibility. Only possibility wins the case here. So, for that reason, there was insufficient evidence at all three stages that we made our motions. Certainly at summary judgment, where they advanced no evidence, simply said there was a genuine issue of material fact, without articulating what the material fact, or that genuine issue was. The same thing happened, so we should never have gone to trial. And having gone to trial, the case should never have been submitted to the jury, because directed verdict should have been granted. Then once we lost at the verdict stage, we should have received judgment notwithstanding the verdict. In all three instances, again, all we were told is the standard's been met, or the standard hasn't been met, and motion denied. That's not sufficient. I could stand up here and repeat to myself, I'm not going to do that. If you have any questions, I'll be delighted to answer them. Otherwise, I'll just reserve my time for a moment.
My Might this case fall under the first type of risk directly associated with employment, whereas here the employer directed Mr. Stamper to go from Orville to Akron?
No, because really what that issue is the first element in a workers' compensation claim, and that is that the injuries must be sustained in the course of employment. Course of employment is time, location, geographical location.
Well, he drove for
Right.
the company.
Right, he did, and we stipulated, we admitted that this was in the course of the
He drove a company truck.
Yes, that's correct, he did.
And he was driving to a location that would be part of his job, so there was a benefit going to the company.
Correct. But that's insufficient to establish the arising out of element, because again, the question becomes, what caused him to lose control of the truck? Now, if he's driving down and he hits a pothole, that's one thing, because we did place him near the potholes there. If the lanes are smaller, that's the risk associated with employment. But on a dry day, normal conditions of the roadway, there being no evidence that the roadway, the truck itself, or any third party impacted or caused him to lose control, the only conclusion that can be reached is that it is that something happened internally, personal to Mr. Stamper, and for that reason, this is at best a neutral risk. I submit it's actually a risk personal to the claimant, but even if you accept the argument that it's a neutral risk, then he has to eliminate all idiopathic causes, and his own doctor's testimony causes him to fail to do that.
Well, under that theory, does he also have to have proof or some, I guess he doesn't remember after the accident, but some to eliminate that he was looking elsewhere and he lost control, or that something fell on the floor, he spilled some hot coffee? I mean, other than idiopathic type of situation, there are a whole host of other things that could have happened to cause them to lose control of the vehicle, right? So it's his burden to
It's his
dispel
burden,
all those?
that's key. There's a footnote, and I forget the case right now, it slips, I think it's Stewart, where they talk about if it's one of two or more possible events, then he's failed to meet his burden. Is this a tough burden? Yeah, it's a tough burden. Are the injuries significant? Yes, but that's not the issue in this case. If there had been spilled coffee, there should have been evidence of the coffee spill in the truck. If there's evidence of some defect in the truck, so be it. If his mind wandered, okay, I wasn't in the truck. We weren't in the truck. No one was in the truck except Mr. Stamper. Okay? And that's just the fact of the case. He has the burden of proof, and he didn't meet that burden.
You're at 3 minutes.
Thank you.
Good morning, you'll have 15 minutes.
Good morning. May it please the court. My name is Kara Dillon. I'm here today with Jake Brandt. We do represent the plaintiff, Mr. Keith Stamper, who is present today with his wife, Lynn, to hear this oral argument. Mr. Stamper respectfully requests that this court affirm the trial court's ruling and continue to grant Mr. Stamper access to participate in the Ohio Workers' Compensation System for the following reasons. First, the trial court did not err in denying appellant Belle Tire Distributors' motion for summary judgment. The trial court did not err in denying the motion for directed verdict and did not err in denying the motion for judgment notwithstanding the verdict. And finally, Mr. Stamper was injured in the course of and arising out of his employment with appellant Belle Tires. On the merits, Mr. Stamper is fully entitled to participate in the Ohio Workers' Compensation Fund. Appellant concedes, of course, that Mr. Stamper's injury occurred within the course of his employment with Belle Tire, but argues that Mr. Stamper's injury fails to rise from the employment itself. This contention is simply, in its purest form, false. However, it seems appellant believes that if they keep repeating inapplicable or inaccurate case law enough, that it may just become true. Appellant seeks to develop what I would consider to be an incidental to employment bar to participating in the workers' compensation system by mixing these slip and fall cases with the coming and going rules, and no such bar exists. Mr. Stamper has full faith that this court will wade through some of these distracting arguments and come to the same conclusion that the trial court came to, which is that he is fully entitled to participate in the workers' compensation fund. I will note that appellant argued Mr. Stamper provided no evidence of what caused the accident, but no such burden actually exists that he could show what caused the accident. That's placing a negligence standard on him, which I will get to in a moment. Appellant does repeat over and over again that there were no disputed facts. That assertion, again, is not true. When looking at summary judgment, we were arguing over whether or not this case arose from his employment and all of the facts surrounding what he was doing at that time, some of what were brought up by you here today, that he was employed by Belle Tire, he was benefiting the employer. Again, appellant asserts that the trial court evaded its duty to apply the law to the facts by transferring the duty to the jury. Appellant didn't request a bench trial, and it went to jury as it should have, and they came down with the right decision, even though the jury instructions stated that driving alone is not a hazard of employment. That came from a case that was from those coming and going rules, and it was broadly brushed in the jury instructions, and even that didn't deter them when they looked at the totality of the circumstances.
So your position is Waller does not apply?
That it doesn't apply as appellant would have construed to you today. I will get to more of that in a moment. Appellant argues that the expert witnesses provided by Mr. Stamper only opine on the causal link between the accident and his physical injuries sustained, and then that the experts, both doctors, did not opine on what caused the accident. We asked, was it from coffee spilling or him looking another way? It just doesn't matter at this point under the law. The workers' compensation system in Ohio is a no-fault system. Questions of fault, blame, wrongdoing, wrongful acts or omissions, neglect are theoretically irrelevant under the Ohio workers' compensation system for both employers and employees, and none of those items are relevant in determining compensability. Appellant failed to demonstrate that reasonable minds could come to but one conclusion in their favor. And in fact, I think they could only come to one conclusion, and that of which they did, is that Mr. Stamper was injured in the course of and arising from his employment with Belle Tire. First, it seems prudent to our cause to state that this case, again, does not fall under the coming and going rules. It does not require proof of a special hazard and does not require an elimination of all the hypothetical idiopathic causes that appellant would have you think of in this regard. Instead, relevant applicable law requires this case be reviewed under the Lord and Fisher standards examining the totality of the circumstances. Appellant spends a great deal of time going through the coming and going rules and special hazard exception and talking about these idiopathic causes. And again, this line of law is just inapplicable. Remember, Mr. Stamper was in the course of his employment with Belle Tire. We've conceded that, and the issue is just whether or not it was arising. So on the date of injury, April 8th, 2015, Mr. Stamper reported to work at 7:40 a.m., started his workday. He was ordered to report to Orrville, Ohio for an assignment. While present at the assigned Orrville location, management called him there and dispatched him to Kenmore Construction, located in Akron, Ohio, and they expected him to drive his assigned boom truck that they provided to him to and from those assigned work locations. On his way to from Orrville to Akron, Mr. Stamper was involved in the single vehicle crash in which the truck he was driving collided with the concrete median, slid 200 yards, and the airbags, of course, did not deploy. The truck suffered over $43,000 worth in damage. Those are all known facts in this case. It's not the coming and going rule because, as we've already stated, he was already on the clock. He wasn't heading to work. He wasn't heading home from work. So the case is cited by opposing counsel, that of Phelps, where the injured worker was intoxicated and heading to work when he was in an accident. Inapplicable here. Mr. Stamper was already engaged in work, and there is no allegation that he deviated or was under any influence of any distracting substances at that time. Appellant also relies heavily on Lempinen and R&R International, again attempting to fit the facts of this case into the coming and going argument. And in Lempinen, the court denied the claim of an employee who sustained injuries following an automobile collision when it occurred on his trip home. So again, not applicable here. Mr. Stamper was already in his course of employment at the time. There's no need for a special hazard exception, but in the event that you would take the coming and going rules, I'll make one anyways. Appellant argued that Mr. Stamper failed to connect the industrial injury to a hazard of his employment. Mr. Stamper was ordered by the employer to drive a boom truck throughout the day, a truck roughly the size of a school bus, as testified, and this, even though it sustained $43,000 of damages, didn't even deploy its airbags. I mean, this is a big machine. And so how that is not a hazard of his employment, I can't understand. But at the direction of the employer, Mr. Stamper was ordered to travel from job site to job site, and I think that's the most important piece here. Once we eliminate idiopathic causes, which we did, appellant listed to you several manifested hypothetical idiopathic causes. He wasn't in the truck. He's not sure what happened. Anything could have happened. The injured worker does not have the burden of disproving every single hypothetical idiopathic cause that someone could conjure up in their mind. What we know is that Mr. Stamper had a pre-existing high blood pressure condition. It was maintained for 20 years. He never had a syncopal episode, and it was maintained. And he testified that even if he missed his medication one day, it didn't affect him in a way that would have caused a syncopal episode. And his doctor, who had been treating him since 1994, testified that he had never had a history of a syncopal episode. And so I think that even under Waller, shows that any idiopathic cause that could be applied to this car accident has been eliminated by a doctor that was testifying on behalf of Mr. Stamper. And although appellant indicates that they have no burden, they provided no medical testimony at trial, no medical testimony at all from an expert indicating that there was some other idiopathic cause. These are just idiopathic causes that they came up with that could have happened, the pothole in the road, or maybe he looked at a deer. They didn't exist, and so they're just meant as red herrings to distract you from what's actually going on in this case. Appellant also relies heavily on Miller versus Horizons Health Services out of the 8th District, hanging its hat that on the fact that Miller hit a light pole, an obstacle that the 8th District determined was an obstacle common to the general public. Unlike the plaintiff in Miller, Mr. Stamper was driving a boom truck owned by appellant, not his own vehicle. And in addition, Miller conceded in that case that the accident occurred because she failed to take her medication, and as I've already proposed to you, taking his medication on or off for a few days did not affect him. His doctors testified even if taking it variably never occurred, or a syncopal episode never occurred, and so those idiopathic causes are still distinguished, and I think that Miller is completely distinguishable from this case. Now to what matters. Mr. Stamper's injury did arise from his employment with appellant. He maintains that the more applicable law here is the Lord case that examines the totality of the circumstances and looks at those 3 prongs: proximity of the scene of the accident to the place of employment, degree of control of the employer over the scene of the accident, and the benefit the employer received from the injured employees present at that accident. In addition, the Supreme Court has also held that the employee's right to participate in the fund depends on the totality of the facts and circumstances surrounding the accident itself, and it should not limit the court's review of an employee's case to only those 3 factors, noting inherent to determining if an employee's injury arose out of his employment is an examination and consideration of all facts and circumstances involved in a particular case. Finally, in reviewing whether the arising out of prong applies, the Fisher test is applicable, and notes that we must remember the workers' compensation statutes are to be liberally construed in favor of awarding benefits. So when we look at the totality of the circumstances, proximity of the scene of the accident to the place of employment, a central portion of Mr. Stamper's duties required him to travel away from the work office or shop in a Belle Tire owned truck to repair commercial truck tires. Mr. Stamper sustained an injury while engaged in permissible activities of employment ordered by the employer, and it's apparent that Mr. Stamper was at a place he could reasonably be expected to be in light of his employment duties and the fact that he had not deviated in any way and no allegation of deviation has even been made. As for the degree of control, that prong 2 is satisfied. Belle Tire had complete control over the vehicle they assigned. They had complete control over his travel itinerary. They told Mr. Stamper, go to Orville. When he was in Orville, they told him, go to Akron. So they had complete control over what he was doing that day, how he was doing it, and where he went. And I think the benefit is certainly satisfied. It's obvious he was performing a service in the benefit of Belle Tire. So when we look at everything together, I think Mr. Stamper is well within the parameters of his compensable workers' compensation claim, and he proved that at every stage. Perhaps Mr. Stamper's case is most likely aligned with the Miller versus Bureau of Workers' Compensation case, in which this very court held coming and going rule did not apply to a workers' compensation claimant who was on the job at the time of his injury and was taking a permissible paid coffee break incidental to his employment even. Mr. Stamper wasn't even taking a break. He was engaged in full work activities heading to his next job assignment. And even so, I think Miller aligns with what he was doing and acknowledges that he was on the clock. He'd already begun his workday. He was at a location he would have reasonably been expected to be. And the court held that the risk of injury was a risk inherently related to the nature of Miller's employment, as it is here with Mr. Stamper, and that he would not have sustained the injury had he not been required to leave the workshop or office in order to satisfy his work duties. This case, like I said, is no different. The coming and going rule doesn't apply. There doesn't need to be a special hazard exemption. Even if there had, I think we've hurdled that burden as well, and we've eliminated any idiopathic cause that could have caused the injury with reasonable medical testimony, and Mr. Stamper, for those reasons, should be entitled to participate in the fund, and I would respectfully ask that you affirm the trial court's decisions and deny the appellant's appeal.
Does Waller specifically limit itself to coming and going situations?
Waller lends itself to the slip and falls, and the Supreme Court indicated that it's specific to those slip and fall instances, and this is different than that. You slip and fall for no reason, right here on the floor, and there's nothing around me that I can hit. They have said may not be compensable. I slip and fall and hit my head on the desk, that's compensable. So then even if you applied it here, Mr. Stamper hits the median, which he uses the Miller codification of the 8th District to say that that would be a barrier that's common to the public, and that's even in that line of law is why it fails. And we're arguing that it's not just the barrier, it's that he was in this giant truck. It's the totality of the circumstances that needs looked at that point, and he was there because the employer put him there in that truck at that time, and the injury occurred. And that covers Mr. Stamper under his workers' compensation claim.
Let's make sure there's no other questions here.
This is a hypothetical question.
Sure.
If he had a bed of his truck, but he was driving his own car to go there to use the truck, taking the same path, all the conditions are the same, except he was driving his own car from Orville to Akron to change tires. Would the circumstances be the same? Would the outcome be the same?
I think he still wins because he's at the order of the employer going where they've ordered him to be, and he otherwise wouldn't have been there if they wouldn't have said, go from Orville to Akron today to fix these tires. So he's still under the employment, under the permissible duties of his job. He had deviated in no way. It's not just the truck, it's that it was their truck, he was totally under their control, and I think that fact is just important and further indicating that he was under that bubble of Belle Tire's control when we look at the totality of circumstances.
Okay,
Thank you all very much.
thank you very much. And counsel, you'll have 3 minutes for your rebuttal.
Thank you, Your Honor. The control about which counsel just mentioned had Mr. Stamper safe from Orville, from Oakwood to Orville, and from Orville to on State Route 8. It had nothing to do with what caused him to lose control. And they do have the burden. If there's no burden, then this is, as long as you're in the course, you win. And that's not the law. There's a requirement of causal link. And the causal link in this case is what caused him to lose control. Now let's assume that he had a bad day and decided, forget it, I'm going to ram my truck into the median. Under their theory, that's compensable. Why? Because he was driving where we told him to. Now there's an argument come back, so now he deviated, okay. The key is they have to prove. I want to deal with Waller for a second. If you look at the second paragraph of the syllabus, it says, in workers' compensation cases involving an unexplained fall, the claimant has a burden of eliminating idiopathic causes. Now, the argument is this is limited to its facts. It's not. If you look just at the end of page 122, after there's a discussion of the 3 risks that I talked about, the court wrote, an employee suffering an unexplained slip or fall, such as in the case at bar, is described by Larson, as Professor Larson, as an illustration of a case involving a neutral risk. Waller is not limited to its facts. We did not advance any medical evidence. I don't need to put in medical evidence when I can cross-examine the doctor that they advance, and the doctor gives me the possibility of a syncope. Which doctor, by the way, you never heard anything about, just now. The size of the truck. If he was unable to drive the truck, that's just too much for the truck for him to operate. That would be a link to employment. But there's no evidence to support that conclusion, or that belief. He drove the truck from Oakwood to Orville safely. He drove it from Orville to a location where something happened, and he drove that safely. So the size of the truck is just a red herring. The law is to be liberally construed in favor of the claimant. That's right. The law is, not the facts. Dr. Marchand kills their case because she says there's an idiopathic reason, or whether that's idiopathic or otherwise, he possibly had a syncope. He passed out. Did he pass out from anything associated with work? The answer is no. And their burden is to eliminate that relationship, not mine. What evidence did I advance? The evidence there is no brake lights operated. The evidence is there's no deployment of the, actually I didn't advance it, the police did. It was in the traffic crash report. Whatever the impetus or the size of this collision, it didn't cause the airbags on a relatively brand new truck with less than 7,500 miles on the odometer to activate.
Counsel, with that, you are out of time.
Thank you.
Thank you both for your arguments today. The court will take the matter under advisement and issue a decision. When we do that, the clerk of courts will mail you a copy of the decision on the day it's released. You can also keep your eye on the Supreme Court of Ohio's website where the opinions are posted. Thank you both again for your arguments today.
Thank you very much.
With that, we're going to be adjourned